Judges must not remain too closed, but they need to be able to respond to the public in a structured manner and in a manner that allows us to hear the public's concerns and for us also to speak to the public. And therefore, we have started doing this using the framework of the Constitution of Kenya, which in the first place says that once a year, the Chief Justice must give a report to Parliament through what is known as the State of Judiciary Address. But we have had many open days. We are now setting up for litigants to come and file their cases at Huduma centers. We do, as judges, attend state functions. The other day we had a big function of the three arms of government at Katiba Day, where we were able to engage. And we also do intergovernmental, so we have been engaging between arms of government, between government institutions. But the public, that is the people who do not sit in government, we have also been able to develop a way of engaging them. We are engaging the public so that the citizens of Kenya can understand how this court operates, the Supreme Court. We want to include your views in how we practice, how we process our cases. We want to share with you summarized versions of our cases, an accurate one. Sometimes what is reported is not what is actually what was decided. We also want to mentor young professionals, and we engage so much in campuses, universities, and we want the members of the public to meet the judges in person. Somebody once met me and told me, when we see you there with your red robe, then when we meet you, there is such a difference. You almost don't look very human when you are up there sitting looking very strict. And yet we're Kenyans, we are humans. We also want to engage. So apart from the bar bench committee, in which we engage members of the legal profession, and the rules committee of the Supreme Court, where we also engage the members of the legal profession, we have insisted that and allowed the Kenyan media to do live coverage of our most critical cases. This may sound surprising to Kenyans, but in many other Supreme Courts, they don't allow this. From the US Supreme Court, the Indian Supreme Court, they don't allow live coverage. But in line with the Constitution, we want the public to access what we do, and we do have live coverage. We've been going to do law lecture circuits at universities all over the country. We continue to do so. We have conferences. My fellow brother will talk about that. We even do community and charity work. We have been supporting a number of charities across the country as a court. And we then, as 7 judges, each one of us who we have a particular interest, we do go and give talks to different members of the community. We have been conducting moot courts with universities, and we have also engaged supporting the LSK with their continuous legal education programs. And then we have the town hall meetings like the one we have today. Before I sit down, therefore, I have explained why we are engaging with you as a public, and I welcome each one of you to engage us today. But I'd like to just, in a nutshell, just introduce the Supreme Court. When you look at an institution, you always ask, I always tell people, ask 5 questions. Who, what, why, where, and how. So when you look at the Supreme Court, who is the Supreme Court? The Supreme Court is composed of 7 judges. The Chief Justice, the Deputy Chief Justice, and 5 other judges. That will be Justice Martha Koome, DCJ Philomena Mwilu. And in order of seniority, because we use seniority in the way we sit in our court, we have Justice Mohammed Ibrahim, followed by Justice Smokin Wanjala, followed by myself, followed by Justice Lanaula, and finally Justice Ouko. Seniority goes by when you entered the court. So for those of us who started when the court was first inducted in 2011, we are more senior in status, not in age, but in terms of seniority in the court. That is who, when the Constitution says the Supreme Court is, it is the 7 judges. We must have a quorum of 5 to sit. So we can sit 5 Sometimes we sit 7 full bench. We determine when we must sit 7 or when we can sit 5. Quorum is a difficult issue for us because it is in the constitution and we're only 7. So we have to organize ourselves so that we're able to sit and to find time to sit, despite the fact that 2 of us have other constitutional duties. Why does the Supreme Court do its work? The Supreme Court does its work because the Constitution says it must do it. And under the Constitution, we are the guardians of the Constitution. Under the Supreme Court Act, we are supposed to assert the supremacy of the Constitution and to provide interpretation of the Constitution, to develop rich jurisprudence, and to focus and reflect on the circumstances, cultures of the people of Kenya, and to improve access to justice. That is in the laws of Kenya and the Constitution, and that's why we do what we have to do. Where is the Supreme Court? So the Supreme Court is based in Nairobi. That is where we sit. It's called the seat of the Supreme Court. However, we have registries in other places. So you can file a Supreme Court case in Mombasa. You can file a Supreme Court case in Kisumu. And you can file a Supreme Court elsewhere. Sometimes our premises are too small. For example, you'll notice in the 2022 presidential election petition, we went and sat in Milimani Court because our court was too small. So we established a registry at the Milimani Supreme Court that the parties could come and file their materials for us to hear, and that is where we sat to hear the matter. How do we hear? So we hear, like any other judges, we hear matters through a cause list. We hear, nowadays, we do a lot of virtual hearings because the Supreme Court has embraced technology. Just Soko will be talking to you about how far ahead we are. Many countries in the world are now learning from us in the Supreme Court of Kenya how to embrace technology. Sometimes we have physical sittings, particularly where we think that we need live coverage, that it's a big enough case for all the country to be following, then we will have physical sittings. But right now, majority of our cases are done virtually, which is helping us to become very efficient, and we are listening to cases much faster. Right now, we are in real time in terms of the cases that we are hearing. Finally, what is it that we do? And that brings us to our jurisdiction. What is it that the Supreme Court can do or it cannot do? Sometimes people want us to do matters which are outside of what the Constitution allows us to do. The Supreme Court has original jurisdiction. For those of you who are not lawyers, means those cases where people can come directly to the Supreme Court without going to another court. And we have original jurisdiction in the presidential election petitions. You come directly to the Supreme Court. You come directly to the Supreme Court if you are a government body or state body and you are seeking an advisory opinion on matters concerning county governments. You come straight to the Supreme Court. Where a judge may have been removed by a tribunal, that judge can only come to the Supreme Court on appeal and not any other court. Then, if there is to be a state of emergency, and we thank God that has not happened yet, but if there was to be a declaration of a state of emergency by the president, then the validity of that state of emergency can only be challenged in the Supreme Court. Then we have our appellate work. And in our appellate work, we have 3 areas. Coming from appeals from the Court of Appeal, you can appeal to us as a matter of right. You can come to us and file a case on the interpretation of the Constitution or the interpretation of the Constitution. You can also come to us and file an appeal if it's a matter of general public importance, but we're very strict about that. So not all appeals come to us. Some appeals will end at the Court of Appeal. But if it's a matter of general public importance, you've shown that this case affects other people, it has an issue that will affect the general public, we can accept it and we can hear it. And finally, it is possible for us to hear an appeal from a tribunal, but only if that is set out in the law. Ladies and gentlemen, I hope I've introduced you to the Supreme Court. And until we open up for further questions, Madam Moderator, that is where I'd like to stop for now. Thank you.
Yeah, thank you very much. From the ivory tower to the people you do serve. Honorable Justice Ouko, you celebrated the Supreme Court at 12, and we'd like to hear, what do you think is a major contribution of the Supreme Court towards fostering democracy? What is the major contribution? We'd like to hear you on that. Thank you.
Thank you very much, Professor Kinyanjui. I'm a lady, Justice Njoki Ndung'u, my Lord, Mr. Justice Nga, my lords and my ladies, Learned Council, wananchi tukufu na wageni. I'm usually very excited to be at the Coast because Coast is my second home. It is in this building that I got the inspiration to read law. Mr. Bubakar knows this history because when I was growing up here, I used to come and just lazy around in the court buildings, and I got to meet such luminaries like Sadiq Alia, Steve Mwangi. I met George Ngombo, Asige, and the list goes on, and that's how I got inspiration to read law. And so I'm very, very excited to be here again. And I also worked here. I was in administration for many years, and so en route to Malindi, where I was going to be the first permanent judge in the High Court, I had to learn the ropes from Mr. Justice Mwera and Mr. Justice Maraga, who are serving here. I was here for, I think, a month before I was thrown into the deep end alone in Malindi. And so I learned a lot from this building. So I'm very, very excited to be here. Just to add, Lady Justice Njoki talked about ways in which we have reached out and opened up our doors. She's talked of CSR, community CSR. Only 2 weeks ago, we were in a place called Kaumoni. I'm sure most of you do not know where that is in Kenya, but Supreme Court judges drove all the way to Kaumoni, to a school of children who are disabled, to go and help them with their needs. We also visit each other. We go to our rural homes. Lady Justice Njoki doesn't have a rural home, so we visit her in Nairobi. But those of us who have rural homes, colleagues come home. And when they come home, they don't just have a meal together with our families, but we invite even villagers to just come and see that these are not angels, these are real human beings. So we do that in order to demystify what people think we are not. We also do media summary. I'm sure you've seen that in the court, just to try and make it simpler for those who are not lawyers. Whenever we give any judgment, doesn't matter whether it's landmark or not, but any judgment, we summarize it in a page so that anybody can read and understand in very simple language. Because we also know that the media sometimes misreport some of our decisions. So those are some of the areas of outreach that we have introduced as a court. To answer Professor Kinyanjui's question on our celebration at 12, it will not be complete without the history of the Supreme Court. I don't know how many of you know that the Supreme Court existed during the colonial period. It was the highest court in Kenya until 1977, when we broke away from the East African community and we had one court of appeal for the East African states. So when the East African community broke down, then we revived our own court of appeal. The Supreme Court was actually the High Court. So we used to have the Privy Council, if you remember, then East Africa Court of Appeal, and then the Supreme Court, then the subordinate courts. So the Supreme Court was there before. Then, of course, fast forward in 2000, I think, you remember the Bomas draft? There was a proposal to include the Supreme Court in our constitution that was being proposed in the year 2000. You remember WACO draft, 2005? Again, the Supreme Court was included in the draft constitution. And if you look at those constitutions, the proposals, you will find even the jurisdiction more or less the same. What was missing in both of them was Article 168.8 that my lady talked about on the removal of a judge. That was missing. And of course, the advisory opinion was also missing in one of them. But they were by and large the same as what we have today. Then, of course, you remember the harmonized draft committee of experts where Lady Justice Njoki served as a member of committee of experts, where they harmonized all the proposals of the Constitution. And through that, I think it was Article 200 at the time, made a provision for the Supreme Court, and the provisions that we have today for the entire court come from the harmonized draft. So that is the history of that background. And so when we were celebrating 12 years, it wasn't even 12, I think it was 13, but perhaps because we don't like the number 13, but that's not the true story. We were meant to have celebrated when we were 12, because the first inaugural Supreme Court sitting, where Lady Justice Njoki was a pioneer again, was on the 26th of October, 2011. In other words, the Supreme Court will be 14 years this coming Sunday, on the 26th of October. So when we were celebrating 12 years, we were actually 13 years, but still minor, we are still children. Because 13, you are a child of tender years. So that's where we are. We are still young, and so if we make mistakes as young people. I'm not saying we are making any mistakes, as I will explain shortly. And so as we celebrated 12 years, we reflected and we said, perhaps in the region, we are the youngest, because Uganda, that has a Supreme Court, they celebrated 30 years. I think the closest to us would be UK, Supreme Court of United Kingdom, which replaced the House of Lords in 2009. And so you can see they are as young as us, because I think they are now 16 years and we are 14 on Sunday. So we are very close. But there are jurisdictions like United States, of course, you know, it's over 230 years. Supreme Court of America has been there for that long. Singapore, I think 132 years. And so you can see, we thought that at 12 we needed to reflect. Have we achieved? What are the challenges? What are the milestones that we've made? And how best can we improve our work? And so I joined the Supreme Court in 2011, as Lady Justice Njoki indicated, and I'm judge number 7. That's how we are known. The baby judge. I'm the one who makes tea in that court. I am the one who makes sure that everybody goes home. I go home last. If you forget your iPad, I'm the one who brings it home. So that's what a baby judge does. So judge number 7 came in with our boss. You can see how it's unfair. You come in together, but a fellow comes to your boss and you become number 7. And so when I came in, I had served in the judiciary for nearly 30 years, from magistracy to the High Court, Court of Appeal, and now the Supreme Court. So from that vantage point, I'm able to see what this court is like compared to the courts I've served. Before I came to the Supreme Court, I was actually the president of the Court of Appeal. And I can tell you, forget what people say out there, this court works. I had my own misconception of the court. I even thought they were hungry for jurisdiction. They used to just grab things and here until I got there. And the work ethics in that court is out of this world. The commitment of the 7 judges, when they conference, when we hear matters, when we prepare, and we have excellent team of support team. Our law clerks, I think, perhaps are the best in Africa, if not in the globe. And so this court, whatever decisions we come up with, is based on very thorough reflection, very thorough conferencing, discussions, back and forth. We can conference even 4 or 5 times on a matter, and we take a whole day to do that. So it's not a run-of-the-mill kind of process that we are engaged in. So I think we've done well. If you allow me to judge that with these 13 years, we've done very, very well. And so when we had our conference, we discussed all the 5 areas of jurisdiction. Only one has not been tasted, the one for state of emergency. But we looked at the presidential election petitions and the other petitions that come to the Supreme Court. And we think as a result of our decisions over the years, the law seems now settled. If you compare the number of petitions that came last cycle of elections, they were nearly quarter, if not half, or maybe quarter of the previous cycle, meaning the areas of contestations have been narrowed down by the decisions of the Supreme Court. If you talk of scrutiny, if you talk of recount, technology, all those areas are now settled. We face no challenges on that. And then appeals based on in the interpretation or application of the Constitution. Again, we have laid the law that only those appeals from the Court of Appeal that reach us either on A or B of Article 163(4) must meet a certain threshold. We reflected during the conference, we reflected during the whole period as we were celebrating, and we think that we have touched nearly every area of law and settled the law in most areas, not in all areas. In fact, I've been pushing that we need to engage, not like this where we are like giving speeches, but get scholars and get practitioners who come before the Supreme Court. On a one-to-one, we pick one decision, Muruatetu, and we discuss, how did you arrive at Muruatetu? Why did you have to redo another Muruatetu? We just discuss all those very controversial decisions we've made. So we think we have done very well, but there's room for us to keep talking to those who understand these things so that we can improve. Advisory opinions, again, we discussed. During this period, we reflected and we said, not everybody now comes. Before, people just walked in. I want an advisory opinion about University of Nairobi, how they lost money. Yet, the law on advisory opinion is now settled. And now I'm not saying that we receive them, because we have narrowed, we more or less closed the door, not in a bad way, but according to what Kenyans envisaged when they donated the jurisdiction of advisory opinion to the Supreme Court. The removal of judges for gross misconduct, again, we have dealt with quite a number. We've dealt with, I think, 2 of gross misconduct. I think we've dealt with 1 based on mental incapacity, which was rather unfortunate, and we even made a recommendation that the judge be considered for pension because it was not out of her wish that she developed a mental state that saw her out of the job. And so we have tested all this, and as my sister says, the only one we don't pray for, but good laws must always envisage crisis, state of emergency. We pray we never get there. At one point, we were on our toes when Gen Zs went to town, and we were saying if it's declared, then the next stop would be us. That would have presented us an opportunity also, not that I looked forward, but an opportunity to decide on the validity of state of emergency. And so I just want to say the following before I wind up, that we've done well in the area of human rights protection. We've done well in the area of democratization, the politics in this country. The Supreme Court has many times brought down temperatures in this country through the decisions that we make. And we are normally not celebrated at home. There's something like that in the Bible. John 4, verses 44. I know that because it's very simple, that a prophet is not celebrated at home. So you may not celebrate us in Kenya, but outside, people imagine that we do a great job. We just received last week an award from the African Bar Association, just last week, from Ghana, for judicial excellence. Don't we deserve a clap? So in the whole of Africa, they looked at all the jurisdictions and only saw the Kenyan Supreme Court. And we got an award. One of us went to Ghana and came with it last week. And so I think we've had a great period of 13 years. A lot more can be done. As we'll be talking about technology, a lot more can be done. But we have achieved quite a lot on the other areas that I've talked about. I thank you, Prof.
Yeah, thank you, Honorable Justice Ouko. And I think the clarion call is that a lot of those cases are on the shelves. I wonder how many of you routinely engage with the cases and critique. I think during the Supreme Court conference at 12, the conversations were robust, and it emerged that a lot of us don't actually engage with these cases. So the clarion call for advocates, for students, and for the other levels of the court is really to engage with these cases. So thank you, Judge. But allow me, ladies and gentlemen, to move the conversation further from what has been to the future. And I'd like Justice, I'm calling you Justice already, Dr. Deche, just, and she's smiling, asking whether it's her. So Dr. Deche, we'd like to hear, there are emerging threats to human rights and the political, the civic rights within the political space that we do have. And the question is, what should the Supreme Court do to address these threats? The threats to human rights and the civic space in these political times.
Thank you so much, moderator, Justice Njoki, Justice Ouko. Justice Njoki came with a brother, but I also have a brother there. Olekina was my classmate, so I also have bragging rights. You can see we had a variety of the tall ones and the short ones in our class. What Prof is inviting me to do is to talk about the situation on the ground. Vitu kwa ground zikoaje? Because I teach research methodology, and we normally talk about the ideal proposition, but then there is the intervening proposition, or how are the things on the ground. But because of time, I'll just lay out three threats and just give some thoughts on what I think the Supreme Court should do about them. And that doesn't mean that they are not doing something about it. But you see, when you come here, it's good to go away with a wish list. So I'll just be opening up that wish list. And these threats are all around us. It's just something that you perceive, you see. The first threat is poverty. Yeah, we are talking about these rights amidst poverty. We are told all indicators, whether World Bank, UNDP, that 2/3 of us are poor. So take a congregation of this nature. It is said, probably it won't work here, but 2/3 of the Kenyans are poor. And the rest of us who are not poor are just one sickness away from joining the 2/3, God forbid. So we are having high poverty levels and social inequalities. In fact, I was looking at the KNCHR report, and I saw Brenda there, yeah, on the complaints. They had done an analysis of the complaints which the Kenyan National Commission for Human Rights is handling. And 48.7% of the complaints had to do with the economic and social rights violation. So there is a marked shift. Yes, we can talk about civic space, which is very important, but when it comes to the economic and social rights, one of the greatest threats is poverty. And this is despite the fact that our constitution in Article 43 says you have a right to health, you have a right to housing. You may ask yourself, whose house? You have a right to food, whose food? Water, social security, education, and so forth. Now, I want to connect it with something. If you look at the 4th schedule to our constitution, the 4th schedule is the one that says, national government, you'll do this. County governments, you'll do the other. All the functions that have to do with the realization of the economic and social rights are with the counties. Yeah, that is the architecture of our constitution. It has placed all those functions in the county. So what am I saying? I am saying that the realization of the economic and social rights in this country are tied to the hip with the issue of devolution. And therefore, there comes the second threat, situation on the ground. The second threat is that devolution in this country is under threat. And it is at 2 levels, both when it comes to the operation of the counties and even the body that oversees it, the Senate. Yeah, I'm talking about all the struggles that the Senate will have with the Speaker of the National Assembly. Of course, I know the Supreme Court has dealt with that, but there is the threat. So what I would want to just mention, and just maybe have the Supreme Court continue reflecting about, is look at that connection between the economic and social rights and devolution. And therefore, if we as Kenyans are to move out of the poverty and to be assured of health, to be assured of food, you know, agriculture is also a devolved function. I think we would really look upon the county to really look at the impact and really protect and defend devolution. And I am not saying that they have not done that, but to be more intentional on that, especially having realized the connection between the two, that it's all about our livelihood and poverty levels. So whether it is a judgment, a ruling, an advisory opinion, I think the Supreme Court should refuse to take that disjunctive view of devolution. Now, this takes me to the third threat. And this third threat, for those of you who are lawyers, it's something that I mentioned in the paper I presented at the South Coast during our conference in August. It is all about the state of our democracy. We are supposed to be a constitutional democracy. Okay, we are a constitutional democracy. But from where I stand, we are a wobbly democracy. At times I wonder, are we a failed democracy? Are we a catalyzed democracy? Are we a democracy sui generis? Because when we have a democracy without an official opposition, what does this mean? It puts the court, the judiciary, and in fact, especially the apex court, and the 2 judges have alluded to that, in a very precarious situation where, you know, the official opposition would shadow and call out the excesses of the executive or of government. But now we have a socio-political organization which is funny, where the opposition has been bought or married, or I don't know whether I'm supposed to be saying this here, but that is where we are in. And I would think that it would be, most of the Kenyans find the judiciary, and especially the apex court, as the final bulwark when it comes to the last bulwark in this democracy of ours, at times which is almost collapsing. So what am I saying concerning those three threats around the economic, social rights, around the threat to devolution, and also around our very weak democracy? I would think that it is very important for the court, for the apex court, to sustain that position that it often takes as just keeping the executive and even the legislature within their lanes. And I know oftentimes it is dismissed as judicial activism, but it is important. So I want to conclude by saying that the population, and especially, and I believe I'm talking for many who are here, they expect the Supreme Court to play a part in animating Article 43, the economic and social rights. And I would, of course, I have already said, they expect the Supreme Court to continue putting the legislature and the executive within their lanes. And I want to also say that this call, the judicial activism, is very much resonates with the CJ's stage, the sustaining the social transformation through access to justice. That is the current blueprint for those of you who do not know about it. And it's good for you to read it, because even as Justice Ouko was saying that the Supreme Court was recognized for its role within the whole of Africa. Now, this blueprint of the president, which is the vision of the president of the Supreme Court, has actually been recognized not just in Africa, in the entire Commonwealth, as a leading blueprint. And all the other Commonwealth countries, including Canada, from Canada to Rwanda, all are now using it. So I think it is important for the Supreme Court to rise to that active role that Sturge calls it to, and continue developing jurisprudence that contributes to the living conditions of our people. And of course, this will not be unprecedented. If the Supreme Court of the US had not risen to the occasion in the case of the case of the Board of Education, Brown versus the Board of Education, that declared the separate but equal principle unconstitutional, then things would not have happened the way that they did. And I'm urging the Supreme Court to keep looking for those Brown versus the Board of Education moments to just turn things upside down, because the Constitution allows you to do that, and the 10-year blueprint under which you are operating also allows you to do that. Thank you very much, Prof.
Yeah, thank you very much, Dr. Deche. And I think this is very in line with what the Supreme Court would like to hear. I think, again, at the Supreme Court at 12 conference, the call to get feedback and even just hearing from litigants and hearing from advocates on the direction the court should go. So thank you very much for that different perspective. But I'd like us to go beyond the local jurisdiction and think about the regional courts and the international courts and ask ourselves, are there best practices that the Supreme Court can look to that relate to human rights and the civic space? Just to hear, what are some of these best practices that the court can look to? Olekina.
Good afternoon, ladies and gentlemen. Allow me to ride on the protocols that have been laid out earlier. So I'll start by addressing my Lady Justice Ndungu, my Lord Justice Ouko, my sister here, and Kinyanjui, and Dr. Mercy, who was my classmate, as she has indicated. And then I would like to also address the judges present, magistrates, all distinguished colleagues who are here. Hamjambo. Jukumu langu ni dogo sana kwa sababu katiba imetueleza ni wapi ambapo tutaangalia sheria na ni vipi ambapo tutakavyoitekeleza. Article 2 sub-article 5 and Article 2 sub-article 6 of the Constitution. I'll just read them for you. The article provides that Article 2 sub-article 5, the general rules of international law shall form part of the laws of Kenya. And sub-article 6, any treaty or convention ratified by Kenya shall form part of the laws of Kenya under this constitution. So our first port of call is to look at the number of treaties that Kenya has signed and the interaction that those treaties have with the issues that we are addressing today, that is human rights and democracy. We also look at the institutions that have been set up by those treaties and how they apply those laws. And we look at the areas of whether we are able to access those institutions and take our complaints, and at what stage. Now, we know that there are similar institutions that have been set up in other jurisdictions. Like, for instance, we have the European Court of Human Rights, we have the Inter-American Court of Human Rights, we have the International Criminal Court, and all these courts have opened themselves up to access by the public. And the question then becomes, what are the principles that they use? So we have the principle of complementarity, which reinforces domestic responsibility. We know, for instance, that if we look at the Kenyan question when the ICC picked it up, and we look at the impact that those cases had on our domestic front and the synergies that we now have as a population with the powers that be. To what extent can they abuse rights without fear of any repercussions? So by having these institutions like the ICC, we see that, for instance, that our democratic space has widened a bit. It has opened more because people are more expressive and they are able to deal with the powers that be without much fear. And then, so it's a commitment to remove impunity so that the processes that are applied there ensure that and because our law allows us to import decisions even from those other jurisdictions. It allows us, because when they are applying the same law where we have signed up to, we are able to apply the same principles that they have from their institute, from those other areas, and also expand our space here. The European Courts of Human Rights has really expanded the area of the democratic society, setting strong standards for political rights. And these are, like, you see if you watch television, you see the number of demonstrations that are held worldwide. And what is it that, and you see some moves by countries to try and narrow that freedom and try to impose restrictions. But the courts have always come up to say that you cannot shut that door. You must allow people to be able to express themselves. And what are the best practices that are happening in that particular space? There's the margin of appreciation principle that is being applied while interpreting some of these laws. And we also see a narrowing of the rights, for instance, of political, those ones who are in the political establishment, who would like to use the laws to try, the people who are in the public, like politicians. The issue of defamation, if people are talking about them and what they are doing, has really been narrowed because there is more scrutiny. They're supposed to be open to more scrutiny, so that there'll be there are very strict interpretations of the laws on defamation when it applies to public figures. And you can check the case of Lilians versus Austria, which is reported it's a 1986 decision. And here, locally, we have the case of Kahio versus Mutua in the 2020, which also applied a similar test, opening up the space in Article 24. Although this is a High Court decision, but we are saying that this is where this is a best practice that can be applied. And then a proactive compliance and monitoring and structural reform program. You see, once decisions are made, and let's say the Supreme Court has made a decision, I think it is good practice for it to monitor the implementation of the decision, so that if they say that a particular law should, it gives it a sunset time, that you must amend this law by this period of time, the Supreme Court should follow up. If it says that certain rights must be recognized within a given period of time, there should be a follow-up mechanism. It shouldn't just be left out like that. And this, for instance, you can find in the case of Gomes versus Lund and others, it's versus Brazil. In that particular, that is how the Brazilian court dealt with it. We know that in our local situation, the courts have also recognized, for instance, in the Katiba Institute versus the Chief Justice, the right of people to, particularly public interest litigation. You go to court and you are not condemned to pay costs. And because that is opening up that democratic space where you can be able to express yourself. And that for me is just one last thing is expanding access to justice. The African Court of Human Rights demonstrates the positive impact of maximizing accessibility for those affected by rights violators. Now, I know that you see sometimes when decisions are made by some of these bodies, like for instance the East African Court of Justice, sometimes they make decisions that our courts might not be very happy about. For instance, the Supreme Court in some of our election petitions consider that we have time-bound interpretation of our law, and so that the question then becomes, how do you marry that with the question of access to justice? Are people going to be, you have 6 months within which to challenge a decision and move from the lower court up to the Supreme Court? I think those are some of the areas that why the court should look and give proper guidance. Thank you very much.
Thank you very much, Senior Olekina. I think just a point to note is that the Supreme Court is now publishing papers from advocates, from academics, and this is a call that for discussions such as this should be included in the papers that are being published by the Supreme Court. We have overshot on time, but we did have just one more segment before we get to the plenary. And I'd just like to ask the panelists to just talk about some of the leading cases, some landmark cases. And I'd like to start with, again, Honorable Justice Njoki, to talk about landmark cases that touch on non-discrimination. Very briefly, Judge, but we would like to hear those cases. You're welcome to sit if you would like to sit in this segment. Right. Justice Ouko, would you like to start and touch on cases that speak to land rights?
Thank you, Professor Kinyanjui. There are many cases that the Supreme Court has determined regarding land rights, and I want to try as much as possible to bring it within the context of the coastal region so that we appreciate that the Supreme Court has addressed issues that concern people living here. Although Article 40 guarantees right to property, Article 40, Sub-Article 6, a proviso that unless your title is clean, unless your title has not been obtained through fraud, then you have a good title. So Sub-Article 6 says that that right does not extend to any property that may have been acquired through an unlawful way. And so in a couple of judgments, starting with, I'm sure the case you all know, perhaps some of the lawyers presented it, Dina, which was decided by the Supreme Court, where we said that a title deed is as good as its root. You will not show a title deed and say I'm the owner without confirming that you acquired it properly. So this was a case where land was allocated to an individual, but public land, and the individual showed the title deed saying it is mine, but it was public land. So that's one. The other one we decided also, this is a Nairobi one, I'll come to a Mombasa one later. This Torino, again, public land allocated to an individual who was waiving the title deed. Again, we reversed the registration of that land and reverted the land back to the state. And there are very, very many. But one relating to environmental justice, Owino Uhuru. I feel really sad that so far it's 1 year since we made that decision, and you are all aware it was something to do with pollution through lead. People suffered diseases, people suffered even death. Homes were damaged and animals died. And it was shown, there was direct link that this lead is the cause of all this. And the High Court, or ELC, found that indeed EPZ and another organization, no, NEMA, were negligent. They let somebody do this where people resided, and the result was what we had. So there was direct causation. That's what the High Court found, the ELC, but the Court of Appeal reversed that decision. In the Supreme Court, we said that there was liability, and we retained the award that they were given, I think 1.6 billion, and I think 700 million to try and clean the area and make it free of lead. That is a win, Uhuru. It is sad that I know the process of payment may take long, but from what we read, it is still a matter that has not been settled. It's even doubtful that they have done the cleaning of lead in that area, and so people continue suffering. Mr. Olekina talked of interdicts, structural interdicts, where courts, Supreme Court, particularly given its very unique jurisdiction, should be able to make orders of follow-up to find out that since we made this decision in December 2024, how far have we gone with compensation? How far have we gone with cleaning the area? But I think we sent it to ELC, and I think we really lost control over that. The last one is Mitubel. I'm sure you remember Mitubel, where squatters were kicked out of Kenya Airport Authority land, and the Supreme Court in its final decision confirmed the socio-economic rights, right to housing, Article 43, that you cannot throw a Kenyan out of land even if it's not their land. You must give alternative accommodation before you do so. And so these are some of the, perhaps one very last one is the case of SEMI. SEMI, this we decided, I think just 2-3 months ago, the renewal of government leases. There are people who were around looking for government leases that are about to expire, and they go for those properties. And so SEMI was a victim where he had and his family had lived for many years. Somebody came and said, now this land belongs to me, this is my title deed, and brought the whole building down where they had lived since, I think, in the 40s. And so SEMI came to the Supreme Court because this was a GPI question. No, I think it was a constitutional interpretation or application, Article 50, I think, no. Anyway, they came to the Court of the Supreme Court, and we said that one, SEMI had himself applied for renewal, but never got even a response or even an acknowledgement of his application for renewal. But yet the government gave this property to somebody else. And so we invoked the doctrine of legitimate expectation that SEMI expected an answer. We are renewing or we are not renewing. And so the jurisprudence is that when leases expire, properties go back to the government. But if the last lessee is keen to continue with the lease and has applied, they must be given an opportunity unless perhaps they are in violation of any of the terms of the lease. And so those are some of the decisions I can think on over land matters. Thank you, Prof.
Thank you. I'll be talking a little bit about some of the decisions that the court has done in terms of human rights on the basis of the non-discrimination clause. Now, our constitution under Article 27 is clear that all citizens are equal and that non-discrimination cannot be used either by the state or a private entity against an individual citizen. There are a number of cases where we looked at this in different contexts, actually. Under, for example, criminal law, in the famous Moroatetu case, we actually determined that because the death penalty was mandatory and did not allow convicts to give mitigation, unlike other convicts in other cases, that was discrimination. And then that led us to make the conclusion that you cannot have a sentence that is a singular one. It's mandatory. So it discriminates. You can't even plead your case, you cannot mitigate. And that was under criminal law. We also have a number of other cases, and before I speak to them, I think it's important, and that's why we have these engagements, to understand what comes before the Supreme Court. What is the question before the Supreme Court? Sometimes you have a topic or a subject that is controversial in many levels, but the questions which are very controversial are not the ones before the court. But the way it is reported, it appears what is controversial or considered controversial. Although we do not shy away from controversy either, we can also make determinations on them, but only when they come to the court. We listened to a matter called Eric Gitari versus the NGOs Coordination Board. What was this case about? This case was traced back to a letter from the NGO Coordination Board, which refused to reserve any of Gitari's proposed names to register an NGO seeking to champion the rights of LGBTIQ persons in Kenya. When the decision came to the court, the question was whether the decision of the NGO was discriminatory and contravened Article 27. When the Supreme Court looked at Article 27, and we also looked at the article that allows for freedom of association, we noted that those rights can be accessed by any Kenyan without exception. And just like anybody else, those persons who wishes to register an NGO to advocate for such rights have the right of freedom of association to register the NGO. However, we noted that those persons, like any other Kenyan, must also obey the laws in Kenya that are already in existence relating to any other matter. So that was what we said in the matter of Eric Gatari. We then have another matter on the issue of non-discrimination, in which we had a respondent. This is in Gishuru versus Package Insurance Brokers Limited. This appellant was employed as an operations manager. He was diagnosed with a tumor. When he went for operations in India and came back, he was confined to a wheelchair, and he was terminated while on sick leave. So we found that there was discrimination in this matter, and that whether one there is prohibition of discrimination on grounds such as race, sex, or disability, or unfair, and that would be unfair practice, that you would terminate a person on the basis of their medical condition or disability. We also, more recently, made a decision in a matter where the dispute was about the right of children to inherit under the Muslim law, where they were born out of wedlock by a deceased Muslim parent, and whether such children could be excluded from benefiting from the estate of such a deceased Muslim parent. In the court, we stated that there cannot be any reasonable justification advanced that would warrant a distinction between children in relation to their father's estate, as Section 27 allows equal protection and benefit of the law of all persons. We also stated that denying children born out of wedlock by the same parents the same benefits accorded to persons born within wedlock on the basis of alleged sins of their parents is unreasonable and unjustifiable. And this meant that any attempt to exclude children born out of wedlock from benefiting from their father's estate fails what we call the proportionality test, the test we apply under the Bill of Rights. So we said that the paramount consideration of the court, not just the Supreme Court, but any court when it comes to children, must be the protection of the welfare and the best interests of the child. And we said it would be wrong to deny a child care and protection on the basis of marital status or on the perceived sins of the parents, that if the parent has sinned, therefore the child should suffer for it. And we allowed for the child who was born out of wedlock, but who was a child of both parents, to also inherit. Finally, on the issue of non-discrimination, actually, the last case I had was not a non-discrimination case. It was a Mombasa case, but I can raise it during plenary. Thank you very much.
Yeah, thank you very much, Justice Njoki. And allow me to discriminate the two last panelists, now that they're on the home ground, to take just a minute each to talk about landmark cases, starting with Senior Olekina on access to justice, and then Dr. Deche on vulnerable groups.
The case that comes to mind for me in terms of the decisions of the Supreme Court and is the case of Mother Karua. I remember in the 2017, is it 2007 election? No, she ran in 2017 where she was running as governor of Kirinyaga. And she went to the High Court and the Court of Appeal. And by the time she got back, she went to the Supreme Court. She was told that the 6 months time within which she was supposed to petition had run out. So she went to the East African Court of Justice and filed a suit. They are saying that her right to access justice had been interfered with by the Supreme Court. And she won. And she was actually awarded $25,000. I don't know whether she was paid. So that's one of the issues that, in fact, I also flagged when I was having my discussion, because what do you mean by access to justice if you can be told that you must finish all your problems within 6 months? And yet it is expected. There's a lot of investment that people do in these political positions that they run for. I think that Abubakar can attest to how much emotional and financial investment is made, and the frustration that people have when they cannot be able to complete or actually exhaust all the avenues that they have because of a time factor. Thank you.
Thank you. On vulnerable categories, I want to just say something about the Winohuru case that Justice Ouko has mentioned, not just only because it emanated from this region, but because it involved vulnerable categories. Actually, the first applicant, I think plaintiff, was a child. There were about 12 when the case was heard here by Justice Anomolo in the ELC court. There were about 12, and the first one was a child. There were very many children. And I think, Nyange, you were in that case. Yeah, I can see some of the people who argued that case here. So I liked it that the Supreme Court stood up for that vulnerable category of children, because most of the beneficiaries of that the 13 billion, 1.3 billion it was, and the 700 million was actually for the soil. So the other vulnerable category was nature. You know, increasingly nature is being recognized world over as a person, as a legal person who can file a case in court. We have the Amazon has gone to court and succeeded. We have some of the big rivers going to court. And there's an article that we normally use in class called "Do Trees Have a Standing?" Yeah, pun intended, because there are trees that actually go to court. Although the soil had not gone to court in the Owino Uhuru case, the court actually awarded 700 million for the restoration of that soil, and the Supreme Court reaffirmed that. So that was with regard to the vulnerable categories. I thought I should say that. But another case for me, which is very useful, is with regard to victim participation. Mlalamishi. You know what normally happens when you come to court as a mlalamishi? Previously your rights were vague. You mainly keep quiet, you give your evidence and then keep quiet. The show is between the DPP and the accused person. And in fact, our Bill of Rights, Article 4950, is all about the rights of the accused person. And those of the mlalamishi or the victim are normally very muted. The first time at least the court was bold enough to assert the rights of the victim was in the Kwekwe case. We are all familiar with the Kwekwe case, Veronica Gitahi, where the girl was shot in Kwale. And the advocate wanted to participate in the Court of Appeal. And the Court of Appeal said, yes, the victim has a right to participate. But the Supreme Court, in the case of Lendrix Waswa, now came up to reassert more those rights of the mlalamishi to participate during trial, not just during trial, but even in during appeal. And then they went ahead and gave the guidelines of the how to participate during trial. And you know, the victims are normally very, very vulnerable, made vulnerable by the constitutional architecture and also by their positions, because they are normally victims of crime. So those are the two that I can talk about now that you have stood up, moderator. I had a third one, but I hold my peace.
Yeah, thank you very much. We are on home ground, so we can allow people to ask questions now. Let's give a round of applause to the panelists. Thank you very much. I think it has been an enlightening afternoon, but we do want to give you an opportunity to ask questions, remarks, reflections. But I would like just to give the caveat that in the interests of time, we will only allow you to ask questions relating to what has been spoken to, and also just remind us that it is not an appeal session on a light note, but let's restrict our comments to what has already been presented. Have a hand there. Could we have a couple of hands? We'll have room for 3. So we have Senior Abubakar there. Could you please have a mic? You could start, Senior Abubakar, as soon as the mic comes. Panelists, I think we can take the 3 and then we'll... Please introduce yourself and indicate if you're directing it to a particular individual or to generally the panelists.
Thank you very much. Because of time, I will recognize the... Because of time, I will rely on the protocols already observed. I have a lot to speak about, but because of the caveat by Professor here, I will touch on. My name is Yusuf Abubakar. I'm an advocate of the High Court of Kenya. I'm also the Executive Director of Haki Africa. I am a human rights defender. I've also participated up to the Supreme Court on election petitions cases. And I have a concern to address the Supreme Court on election petitions. You have done very well in defining the law on election petitions. And my observation is that we can even reduce the quota, Justice Ouko, further if we take the right to scrutiny of votes seriously. We can actually eliminate most hearings on the basis of the reports we get from the scrutiny. So I urge the Supreme Court to look at the scrutiny as a window where you could deal with many election petitions in a very short time. Number two is the issue that my senior Olekina has addressed you on the 6 months time frame. I was a victim in 2017. I won appeals in the High Court and the Court of Appeal, but when I went back for my election petitions, I was told the 6 months time has ended, and I was wondering, is there no automatic stay of time when you appeal? In my view, looking at the various provisions of the law, I think there is a window for an automatic stay of the running of time, so that when you go back to the election petition, you start from where the appeal was filed. This is food for thought for the Supreme Court. Number two, habeas corpus, because we have gone to court on habeas corpus. It's very difficult in court. I know this is at the High Court. It's very difficult to convince judges that police have abducted, have actually they enforced disappearance caused by the police officers. But when you look at the circumstances, they all indicate it is a security personnel. If you look at the evidential burden to habeas corpus, it is even way high than beyond reasonable doubt. In murder cases, I've done criminal cases, we have seen people convicted on circumstantial evidence, but there's no room for circumstantial evidence in habeas corpus cases. So if you want to expand the democracy and human rights regime, I think we need to come up with a way, and I'm glad High Court judges are here listening to me. We need to look at this evidential burden when it comes to habeas corpus cases. Lastly, our concern. We have, from Haki Africa, we have, you've done very well. We've done an evaluation of Supreme Court. You've done very well. But we have a concern, Justice Ndungu and Justice. After the 2017 election petition case, it's like you are developing cold feet, the Supreme Court. It's like you've been intimidated by the state and you are losing your grip. As human rights defenders, we are scared that things may not go the pre-2017, where you exhibited the boldness, the courage to confront human rights violations. The perception we have is that you are now intimidated. Please don't be intimidated. We are with you. Continue with the courage you had previously. There are many other things, but let me give my colleagues an opportunity to address you. But thank you very much for this occasion. And sorry, I think Justice Oko said Justice Ndungu does not have a rural home. we are offering Mombasa as our rural home.
Karibu Mombasa. Anyone else? I saw a hand. Yes, please.
Thank you, Prof. Like my brother has done, I relied on the already established protocol. Justice Ndongo, the last born, Justice Ouko, continue giving people tea. It is in the best interest of the nation. I just have two issues which are important. Your recent decisions around the question of public participation. We have a feeling from the civil society fraternity that we are not tightening the space for people who hold responsibility, especially at National Assembly, county assemblies, and people at the executive. And I want to demonstrate this. The Constitution of Kenya and established statutes put a very detailed way of conducting public participation with regards to budget process. So the 6 counties of the coast in the last finance, the last year, we approved budgets going to 69.4 billion. That is the budget that went to public participation and people participated to them. Then when we looked at the control of budgets report, we ended up with budgets that end to 75 billion. That means that there were changes in between the point when documents were taken to public participation and the point when these documents were acted upon. Then the actual amount that was allocated to those monies is 67 billion. That tells you that there was a positive deviation of around 7 billion to a budget so that it looks like a budget. But then the actual thing is we could not even get that money to fund those budgets. So we end up with counties with projects that are hanging, that are not tightened up. And this question has also been pointed out in a number of ways, and it relates largely to stealing of public resources. I may not give the details of that, but when the Court of Appeal stated very clearly that state institutions and people who bring documents, including laws, to public participation, have a responsibility to explain the deviation from the actual thing and what was brought to public participation. I think we went down as Supreme Court. We saw, at the point when that decision was made, we saw the National Assembly even coming up with some detailed documents of what to feel when. Immediately that decision was reversed with the Finance Act of 2023, they completely changed. And so it is documents that are brought so that this public participation is not taken very seriously. So that's a matter that I would request that the Supreme Court looks to very keenly. Finally, I wanted to speak to one positive thing that the Supreme Court did to Mombasa. Towards the run to the last election, there were candidates that were coming. One candidate was almost winning in Mombasa, but unfortunately that candidate had been, the process had taken him out in Nairobi. And for that reason, we went up and got candidates and set a good precedent that if you are in office and you mess up and you are taken out, it may be very difficult for you to come. The question of concurrence between bills that come from Senate and National Assembly is one that has hurt even the civil society fraternity in this region. And so it's also one that I know you've looked at it in detail. It's also a place that you need to look at keenly if we are to expand the place for devolution. So that I let you know, we are seated almost 50 meters to the building that was not completely done, or it was done, but you know what ended up. The question of holding people responsible and opening transparency is a big question for this nation. And we look upon you. You can look at the general atmosphere in East Africa. You look at what is happening in Uganda, where, so if Supreme Court stands properly with the rule of law and accountability and transparency, Kenya will continue to get to the best of the best. Ya mwisho, wakati the presidential elections, I know they are coming, they sometimes get very heated, and I know sometimes you get very tempted. I don't know how you manage that environment. It is my very humble appeal on behalf of the Coast Civil Society Network for Human Rights that as you give your decisions, read the mood. Let us speak responsibly to Kenyans so that even if they are hurt, they feel respected. Thank you.
Yeah, thank you very much, Adika and Senior Abubakar. Together they have asked 6 questions or 6 remarks, and so I will presume that they have spoken to us, but I cannot see. There's one last comment. Just ndugu yetu right here. We have overshot on time, so we seek your indulgence. Allow him to make his remarks.
Our Lords, the Supreme Court of Kenya, and the judiciary. Is the speaker on? Our Lords, the Supreme Court of Kenya, and the judiciary, and the dignitaries at large, with all protocol observed. My name's Athman Sharif, and currently here I'm representing the anti-LGBTQ movement in Kenya. Our biggest concern, I have 2 contentious issues. The first one and the second one have been touched upon by Madam Ndungu. The first one is about, of course, self-explanatory about the anti-LGBTQ. This actually refers to the ruling of the Supreme Court in 2023 that allowed the registration of LGBTQ organizations. We know very well that the same-sex sexual activities are prohibited by the Constitution of Kenya, the Penal Code 1930, and also the, according to the Constitution, 2010, Article 45(2), also criminalizes self-sex relationships. Regardless of both, and also regardless of the fact that the current statistics of Kenya of LGBTQ persons are just a mere, maybe 1 million. Proportionally, it comes to about between 1.5 to 2% of the total population of Kenya. And in spite of the fact that there was an outcry of protests and demonstrations before you effected the ruling, and I think the outcry was from all corners of Kenya, from all corners of life, from all the religions, starting from Muslims, Christians, Hindus, and other smaller religions, and other traditional religions, including Kaya, for example, because I remember we had to consult all these groups to seek their opinions and ideas about the LGBTQ issue. And we all agreed that this one was against our society, both the religion people and the non-religious, like the traditional religions. The Supreme Court went ahead and effected. It did not listen to the people. My colleague just said here, and the last word he told you is to listen to the society. There was a major outcry because already there's a big threat for the LGBTQ persons in the society. I think you're aware of that as a judiciary. We as anti-LGBTQ persons here in Mombasa, we are considered, we're looked upon as policing for LGBTQ issues. Whenever they have an issue, and we are actually the Makupa police's testimony to some of the lives that we have saved as anti-LGBTQ, the lives of these people who are sodomizing children in the society. Every time they catch them, they call us. We tell them, wait, we're coming there. We'll link them together. But we want to try the police, and we always come with the police and have saved these people's lives. We have OBs in Makupa police, for example. It's showing that the society is very angry with this act and these people. And if our intervention, for example, is we stopped intervening in these kind of things, there'll be a lot of killings, mob justice on the LGBTQ persons. So it's showing what the society perceives these people so far. I've given examples of the proportion of the people comparing the society, how many they are. I've given people's perception. Then the Supreme Court has a moral and social responsibility to ensure that before effecting any law, you have to listen to what the society and the people are saying. So our concern is we feel that these rules were affected, the ruling was affected a little bit earlier. Maybe you needed to do more research and work with the people to understand actually the people's perception towards these issues. The other, finished. Okay, thank you very much. We appreciate, we acknowledge you are coming here. We really appreciate your, it's actually, we can say, coming down to us. This is an opportunity that we'll never forget. I'm 60 years old. My 60 years in this Kenya, I've never seen something like this. So we're really delighted about it. Thank you, madam.
Thank you very much. And it's a very hard task to cut you short, but thank you for your contribution. Allow me now to request the honorable judges to respond in no particular order.
Thank you so much, all of you, for all your interventions, your questions, your comments. It's so very interesting to hear always what members of the public, what the people of Kenya are saying to us. One of the things that occurred to me when I listened to Dr. Ndeche, Councillor Olakina, and some of the questions is this. What is it that the Supreme Court can do, and what it is that it cannot do? Because as a people of Kenya, we sit in different institutions. We have 3 arms of government. We have the people who vote in that government. We have institutions that are supposed to deliver services to the people. Everybody has to play their part. And sometimes, and I hear the cry, sometimes in the Supreme Court we hear things, but can we do those things? Let me give you an example. For example, Mr. Okina has talked about the constitutional timelines. So did Mr. Abubakar. Constitutional timelines for filing petitions. It is in black and white in the Constitution. Black and white. So as courts, what do? We follow what is in the law. It's difficult to make an exception, although Mr. Abubakar, perhaps you want to explore that, file a case in the High Court and see whether the issue of stay is something that can be explored. But for us, timelines have to be followed. Can you imagine if the Supreme Court failed, because of access to justice, failed to follow the timeline in the presidential election petition? And we came and told you, as the public, after you watched us on TV, we say we know we are supposed to give you a decision in 14 days, but because of access to justice and because A, B, C, D has not been done, we are extending by a few days. We will be in a lot of trouble because what has given us the authority to extend? The Constitution is clear, and the Constitution came from the people of Kenya. So what I'd like, I think, even for civil society, for the religious groups now to start thinking around, is this Constitution working for us the way we envisioned it in 2010? These timelines, which were put in because timelines were being, people were abusing the courts. So you file a case, and then your case is never heard until the next election. So that was the reason why the timeline was put. But now we are seeing there are also people who are suffering because of that timeline. But it has to go to the people, and the people have to make the amendment to the law. Because if the courts start amending the constitution on their own, amending the laws on their own, then it will be a problem in terms of separation of powers, but also we can overstep. So sometimes we have to be careful. Judicial activism, if not careful, can become judicial autocracy. You've had people saying, you see these people, they are not elected, and look at what they're doing. So we have to be careful always as judges that we are keeping within what we call the boundaries of the law, even where we hear and we may sympathize, but our hands are tied by the law. I think, again, you've given me a lot of food for thought. Maybe in the judges' colloquium, we will discuss the issue of habeas corpus and the burden, and whether that is something we need to think through as the judiciary. It's a big concern. I've heard you. We are Kenyans, so we also see what you see. The question is whether the law allows us to move forward. I also wanted to say that, please, we hope we're not intimidated by the state. We hope. But also, and we plead with you to understand us. Intimidation also does not come also from the state. Intimidation will come from religious groups who say, you must decide this way. I'm saying this tongue in cheek because my brother has just spoken, but you have to understand. So in the end, we just have to look at what does the law say? Because whatever we do, years from now, people will check and see, did they follow the law or did they not follow the law? On the issue of public participation, I was very interested to hear what you said, Mr. Kida. I just wondered whether you have had the opportunity to read our judgment in detail. What has happened is that the National Assembly, or Parliament, has not enacted a law on public participation. And therefore, the detail on how public participation should be conducted is what the challenge is. We raised this in our decision in BBI, and we gave principles, like we should as a court, what should be the guidelines for public participation, and we asked Parliament to enact a law. When the finance bill matter came to the Supreme Court, again, we reminded Parliament, you need to enact a law that gives a detailed procedure, and these are the principles that we would like you to put in. But in the end, the Supreme Court cannot enact the law for public participation. If you look at our last decision, again on the finance bill, we actually added a step. We have told Parliament that where they go for public participation and that there are changes, before they go for the third reading or signatures for the president, they must have public participation on what they have changed. So I'm hoping as civil society or the watchdogs that also follow up to ensure that this is done. But in the end, we need to talk to our elected members of Parliament and follow up with them so that they can enact the law. We have been very reluctant in the judiciary to move in that direction. I don't know how many of you have read Moratetu, and recently we had a case, Republic versus Gishuki, where we said, look, even where minimum sentences may appear harsh, a judicial officer cannot change the law. A judicial officer cannot determine what is a life sentence. That is in the province of Parliament. And so Parliament must do their work. So even though we will work for the public, I would like to encourage you to also, where the other arms of government are not yet doing what they need to do it, because our boundaries, there's a place where we are unable to cross as courts. Finally, let me just say this again and repeat it to for the sake of Mr. Adman Sharif. And I understand his cause, but the courts don't have courts. What we have is parties who come before us and they argue what the law is. The parties were the NGO board and this individual who wanted to register an NGO. Now, the activities that you're talking about were not before the court. The concerns that you have were not before the court. What was before the court is registration. When I became a judge of the Supreme Court, and I was coming out of activism really into the court, so we'd get cases and I'd want to write about everything. I'm like, this case, why can't we say this and this and this? And they say, no, you have to only stick to what the parties have brought to you. You can't start saying, but I also think we should say this. And I also think we should say this. Some of the issues that you are talking right now are sub judice. They are before courts of law. And we shall wait to see what courts determine on those issues. But the matter that was before the Supreme Court did not relate to the activities that you're talking about, but rather the right for registration of an organization by a government office. Finally, and please, I hope I don't sound defensive, but I think sometimes it's just good to talk about the things that we must do. Again, for Dr. Deche raised a lot of issues which I was thinking about. Again, what can we do? Always comes when we introspect. Even as we take to Parliament budgets, the money never comes back to the judiciary what we need for asking. So again, the judiciary does not hold the purse strings. We know who does. And so therefore, we all negotiate with the institution that holds. And I just wanted to say this. And the other day we were in a meeting with members of Parliament. We were, sometimes as arms of government, we meet to discuss things. And they had also many concerns, different of course, that you raised. And we were careful to say, we must remember that courts cannot do politics. Courts cannot do political things. Courts, we can only do what is legal and what is in the law. A lot of people want somehow to have a quick fix through the courts. Because you come to court, the court make a decision, but that's not how the architecture of the Constitution presented it to us. There are lawmakers, there are those who make the laws, there are those who implement, there are those who provide the services. Devolution has come before us, we've been concerned, but we make recommendations. We say, if you want to do this, why don't you amend the Constitution? So I think if I can just leave it there, I'm not sure if I touched on everything that was raised, maybe I'll have an opportunity to come back to it, is to say this. It might be time, 14 years later after the Constitution, to look at the architecture of the Constitution and say, what is working for us and what is not? And then to use the channels that the Constitution provides us to make those changes. We live in an imperfect society. Our institutions may not be working as well as they should. And I think as people, as the citizens of Kenya, we should take up the mantle like we did. We did it in 2000. We did it in 2010. It's possible to do it again and to just panel beat, not to change the entire Constitution, but you can panel beat it where it is not working. So let me, for now, those are just my initial remarks. Thank you.
Thank you very much, Dr. Deche, Mr. Lekina, and those who have asked questions from the floor. I just want to assure you that the reason why we came here, although we love the coast, but this was serious business, and everything you have raised, you can see there's a desk on our left, people taking notes, we are even recording. This will be shared because we are here representing the other 5. Our next opportunity when we meet, which I think is on the 4th, is to share with our colleagues the sentiments that have been expressed here. Perhaps in future, this is the second such event that we are having. In future, perhaps we should have a longer period than just 2 hours, 3 hours in the afternoon. Because looking in this tent, I know there are people who have questions that they would have wished to ask. But of course, the time has gone, and as you can see, the moderator is not even sitting. So I think in future we should start in the morning, go for lunch, come back in the afternoon. So we exhaust so that our visit to the coast or whichever part of the country, Turkana, is meaningful. So Lady Justice Njoki has actually answered all the questions. Perhaps I'll just add this on public participation. Very, very good point made, and good examples. What we said in Finance Act 2023, and I think Lady Justice Njoki said that once you go out and you hear the people, you go and you don't have to take everything that people tell you. Some of them may not even be practical. But those that are relevant, those that are fundamental, must be taken. But should you change the original bill drastically, based on even public participation, it's important to go for a second round so that people know when the final product comes out that all the views received have been incorporated. So we have said that in the Finance Act. And we've said, we have even drawn parameters in BAT and so on and so forth. And we've said many times, I think 3-4 times, we've told Parliament, please, let us not rely on courts to make these laws for you on public participation. Parliament, I know there are, I think, 3 or 4 bills that are lying there. They've just been introducing them each time we make a recommendation. Then they don't go beyond first reading. So it is wananchi to put pressure on Parliament so that this area is streamlined, so there are no questions on public participation. The question of timelines, really, even when I joined the court 4 years now, I was baptized by fire. We got there with the Lady Chief Justice Martha Koome. And the first case that came was presidential election, real baptism by fire. First, the petitioner is supposed to collect this evidence within such a short time, and the evidence is with your opponent. And then the courts are supposed to decide within such a short time. Again, an opportunity presented itself just to test the political class, where they proposed to amend the Constitution. And we thought, and we actually made a presentation, that these timelines need to be expanded, to be reasonable, to be realistic. BBI that was presented had nothing to do with these timelines. I think it had things to do with the Prime Minister and 2 deputies and things like those. And when we lose elections, we say, oh, there was no time to even collect evidence. And there was an opportunity. I don't know whether NADCO has these proposals. So we will be blamed for all these things, yet they're beyond us. Whether we've developed cold feet, whether we are intimidated, I don't think. I mean, no 2 cases, no matter how closely alike, can be exact the same. And so a decision that was made in 2017 cannot be replicated in 2022 merely because we were then bold. And you know, the judges have not changed, apart from 2 of us who came in. The judges, the majority, 5 of them are still there, those who made the decision in 2017. So it cannot be intimidation. It is evidence on case-by-case basis. The last thing I want to say is about LGBTQ. I walked away from my colleagues. I dissented. And I stand by my dissent because I have my reasons if you read my decision. But I think by and large, this case has been misunderstood. And that's why we urge people always to read. Don't go by social media where they do a one-liner and we are all carried away. This was about registration of this organization. It was not to legitimize LGBTQ. It had nothing to do with that. In fact, I'm told there's a case coming, perhaps it's now in the Court of Appeal, that deals specifically and squarely with these questions. Certain provisions in the penal code that I relied on to be repealed so that people can have freedom to associate and to do whatever they want to do as adults. But the lesson that we must all live here with, at least if you're not going to read any other decision, read decisions from the Supreme Court. But I urge you to read all decisions. Don't rely on those experts who come on TV, constitutional lawyers, and they were not in anybody's class, and they're saying the law is clear, and we never saw them in college. So please, let's read, and that's why we go out to talk to you, to explain to you some of these things, instead of relying on, I don't want to call them quacks, but that's what they are. So thank you very, very much for the opportunity.
Thank you very much. With your patience, we really do appreciate your patience. And I'd like to request that we now allow the panelists to give us a parting shot. I'm looking at the honorable judges. Is there anything else, or should we just go to the parting shot? Justice Njoki. Right, we could start with Senior Olekina. Parting shot.
The lessons that we have learned and which we will continue to learn as we apply our constitution is that the greatest thing that we ever gave ourselves when we passed this new constitution was the Bill of Rights. And the fact that we have also made it a duty for all our institutions, and whether be it the courts, be it private individuals, be it organizations that we work for or we work with, to ensure that they comply with the Constitution whenever they apply any law, is a very significant gain that our people made for themselves. This is something that we copied from other jurisdictions, and that is why, particularly the South African situation, and that is why I think we also made part of the international law and all the treaties that our country has signed part of our law. And you can see from looking at the judgments, be it from the High Court or even to the Supreme Court, there's always a reference to decisions from other jurisdictions, and those ones enrich our experience and actually the output that we get from the courts. Thank you very much.
Thank you so much. My parting shot. Thank you. I was waiting for your ears. My parting shot is actually lifted from the Sturge Blueprint, which is the vision of the president of this court, where he says that justice is best served when woven into the tapestry of everyday lives, paying attention to the context. So I just urge the Supreme Court to keep adopting a broad concept of justice in all matters. Push the much that you can, regardless of what the Constitution is saying, and develop jurisprudence that contributes to improving the lives of our people, us people. And I would also urge that to avoid the miscommunication that is apparent on the Gitari case, because actually it wasn't even about registration, it was reservation of a name. And it would be good to keep generating the popular versions. I don't know whether there was a popular version for that, and popular in as very, very brief and precise, and if possible with the pictures and colored, because we don't want to read boring things. Just find a way of communicating in a way that will be very edible to the common population. Thank you so much.
Thank you, Dr. Deche. Honorable Justice Ouko.
Thank you. We nearly went to war in this country. People lost lives. People were maimed, property destroyed, people were displaced. And we called foreigners to come and help us because we said we didn't trust the court system, that the court system was weak, inept, corrupt. And Kenyan people brought reforms that saw so many of our colleagues go home, and the courts were reconstituted, and the Supreme Court was created because Kenyans said we want another chance above the Court of Appeal. And so the Supreme Court came. It is 13 years with all its weaknesses that we have had and we have taken on board. And all we are asking is to give this court time, correct it when it is not, when it's necessary, criticize it when it deserves to be criticized, but give it a chance and praise it when you must. We don't want to praise ourselves. What do they say about Mugema? So usitusifu sana, kidogo tu, when we are right. And so that's what I want to urge you to do, to give us a chance, and we promise, listening to Kenyans, going around the country, the lessons we are picking, and you will see this court going to higher levels. Thank you.
Thank you very much. I just want to add on to what my brother Justice Ouko is saying. As you all know, the Supreme Court is the final court, and therefore our decisions are binding on the courts below us. And this is so that as a country we have certainty, stability in terms of our court decisions. But the Supreme Court can depart from its own decisions. It can't be done frequently, but it can be done. And therefore, where we hear that perhaps we ought to have gone another way, we discuss and we see it is possible, and there is a way to approach the courts, not as in an appeal, but in a similar case, to ask for the court to depart from its decision. So the door is not completely closed, and Supreme Courts, like other Supreme Courts all over the world, can correct themselves. So this is why we continue to engage, to listen, so that this goes beyond the 7 of us, and we hear what else or where else things we ought to have done. The second thing I'm hoping is that you've seen how comfortable we are as a team. He dissents, I dissent a lot, and we still work as a team. The other day I went to do a continuous legal education program for the LSK in Nairobi, and I found myself presenting in the topic separation of powers. And I presented all the Supreme Court decisions in separation of powers as the majority had presented, because I had dissented in all of them. But I did not present my dissents. My dissents are for people to read, but the decision of the court is the one that the majority have done. But we like it that way. There's democracy. Then we argue, we say we don't agree, but we are still a team that is unified in terms of our purpose and our commitment to serve Kenyans. Finally, just to say that one of the lessons taken from today is that we need to start putting our decisions in much more simple terms. Because even though we do the media summaries, I think we still use a lot of legal language, and so people are able to talk about what the case is not about instead of what the case is about. So I think we'll take that back as a Supreme Court and think around our key decisions. How do we let people know what we said? Like the public participation, when I saw the discussions in the social media, they are completely not what actually we stated. But I think we need to know how to be approaching it so that wananchi know exactly what it is we said, exactly who the recommendations have gone to, and exactly what we have said as to how the resolution of that problem can be. Finally, just to say, the Bill of Rights is ring-fenced in the Constitution for a reason. You cannot amend anything in the Bill of Rights without going to referendum. That is how important it is to protect those rights of Kenyans, to allow any Kenyan to come on their behalf, on behalf of other people, to claim those rights. Let us keep on claiming our rights in the Constitution, using both the court processes and the other processes which the Constitution provides for. This has been a great very short time, though I agree. Next time we should start in the morning. I think there are many of you we didn't hear from and we would like to hear from. However, please, if I can welcome you, look us up on our website. The Supreme Court actually has a pretty good website, I think. You'll find all our decisions there. You'll find all the papers that have been written by the judges. We have now written, and we even have journals which are published on our website. We have papers which were presented last year at Supreme Court at 12, where we invited people outside of the court to criticize and critique our judgments. Those papers are also on the website so that you can see what other people are also saying about us, about what we have done right or wrong. So we have a website. Please, you're most welcome, and let us know what you think of the website and how we can improve in terms of our engagement as a court with the public. Thank you very much.
Yeah, thank you very much. A round of applause for the panelists and another round of applause for yourselves for staying the course. So thank you very much. We really appreciate. Just in terms of closing, I think a few things that we pick out from this conversation. Number one, this is just one of the town hall engagements. The Supreme Court has indicated that this is a continuous engagement and next time with a different focus. The second thing that we pick out is that the Constitution is as good as its interpretation, but also the interpretation is as good as the submissions. So I think the clarion call is also, as you identify these areas that you would like to critique the Supreme Court, is to take up matters where you're able then to discuss the issues that you think require reform. Ladies and gentlemen, we really thank you for being a very good group of participants, and we thank you and look forward to the next engagement. I'd like now to request Ubonyo from the Law Society of Kenya to come and give a vote of thanks, and then we'll hand over to Honorable Wachira for the last part. Thank you.
To the organizers, our panelists, and all other participants, good afternoon. Good afternoon. It is my pleasure to thank you for being here for all this time, and particularly we wish to thank our learned judges, Justice Njoki Ndung'u, Justice William Mouko, our other panelists, Senior Tukero Lekina, Dr. Mercy Deche, our presiding judge, Justice Jairus Nga. I can see Justice Kibunja has also sat patiently. We see our Chief Magistrate, Honorable Ithuku, our learned magistrate from Kwale, Honorable Lewa, Honorable Mwamuye, Honorable Viola Mudhoni, Honorable Mbata, as well as our other organizers. We have Honorable Kasavuli, as well as Honorable Wachira. To other participants, we can see participants from the prison department. We can see our colleagues from the learned institution of the Law Society of Kenya, through the Mombasa Law Society, and through our able chairperson, Madam Natasha Aliere. To members of the public and other members of the civil society organization, we can see our Honorable Abubakar and Honorable Adika also present. We wish to thank you, and if we have not mentioned you, please know that you're well appreciated from where you sit. Our take home is about the approachability, availability, and accessibility of the Supreme Court through the social transformation and access to justice as the ongoing theme for the next 10 years. Now, at this juncture, and not to say much, allow me to request you to have one final round of applause for each and every one of you who has participated. Kindly. Thank you so much to our very able moderator, Professor Kinyanjui, for making sure this has been done well. And to the students from the University of Nairobi for learning, coming, and also seeing through that this noble profession shall continue the way it is. Thank you and have a good afternoon.
Thank you, Mr. Obonya. We also thank you because of giving us the vote of thanks. So, Honorable Judge, before we finish up, I will request that you recognize by giving a little gift to some of the people who have been with us, who have helped us as we planned around. So I request that you come down and hand over a gift to Honorable Justice Ga. He has been with us all through, Judge Joki. Just give him. And the next gift will be given to Honorable Justice Kibunja. The third gift will go to Honorable Justice Baru. I know she is absent. One of the judges can receive on her behalf. And the last one, Honorable Judge, will go to Professor Sarah Kenyaji for moderating us all through. May I request Honorable Justice William Ouko to come down and give also a few gifts. Judge, you may take a seat, kindly. And the first gift to be given by Honorable Justice William Ouko will go to Dr. Mercy Deche. The second gift will go to our very own member of the bar bench, Mr. Olekina. The third gift will go to our very own CM, Honorable Alex Itoku. And finally, we'll have the LSK Mombasa Chair, Natasha Eddy. Thank you so much, Judge. And that is all for the gift. I will invite Zakim to now guide us on the photo session. Thank you.
really started when I was very, very new.